Hey, it's James, Father's Rights and Resources, hashtag how I got custody. I want to talk about when the courts order an investigation into whether you're abusive, whether you have a mental disorder, whether you got an anger problem, and they order a parenting evaluator or guardian ad litem, and in the meantime, you're on supervised visitation or restricted visitation or get very little visitation. This is insane because they're sentencing you as if you're guilty. And that's backwards, and you should speak up about that. If you get railroaded at a hearing with something like that, I would be doing a motion for reconsideration. Or if I'm in front of a family law commissioner or a magistrate or a friend of the court, I'm gonna appeal to them, and just like I would any decision of the court that's wrong or unlawful or unjust, I'm going to do a motion for reconsideration, and I'm going to appeal that if there's an appeal opportunity. Think about it. If you guys know chalk, this is why I tell you guys all the stuff that I tell you so you can piece it together. But a lot of people don't piece it together because a lot of people don't study this stuff and absorb it so that they know it. If you read about your rights and under the law, under United States Supreme Court constitutional case law, and you look at the science and the data and all that stuff, you'll be able to slap all that stuff together so when somebody comes against you, you could back it up and regurgitate it because you've read it to absorb it, not just glossed over it to read a couple words like the average student does in America nowadays. They just read material, they don't study it, they don't practice it, they don't absorb it, they don't visualize how it applies to them or whatever, or picture, like if you're reading history, you picture the events of a historical event or something, or whatever. You got to look at like the statutes, like if you're looking at Florida, 61.133. And you look at the factors, and one of them is which parent is willing to facilitate a relationship with the other parent. And then you think, wow, my baby's mom totally flunks that. She's been withholding the children for no good cause. She doesn't honor the parent-child relationship with the father, etc., etc. You look at it and you say, the mental health and physical abilities of the parent to parent the children. Well, the mother's acting like a psychotic narcissist, sociopath, passive-aggressive narc, or whatever. And I have evidence of that. I'm going to ask the court to do a psych eval on her. So that's why you got to look at that stuff and absorb it. And here's how you put stuff together. Here's an example of putting stuff together. Troxel versus Granville says, we assume that a fit parent acts in the best interest of the child. So they're taking you away from the child because what? They're going to go and investigate if the mother's allegations are true. Big I, capital F. So you inherently have a right to autonomy with your kids under Troxel versus Granville. They have to assume that you act in the child's best interest. So why would they take a parent away from the child if you do what's best for the child? Because you didn't stand up in court and tell them that. Your Honor, you have to assume that I act in the best interest of the child. Why would you take something that's good for the child away? Are we going to take fruits and vegetables and water away from the child? Are we going to take exercise away from the child? Are we going to take, them getting outdoors and getting sunlight? Or are we going to lock them in a room? We know the things that are good for a child. If a child has a favorite teddy bear that helps them fall asleep, are we going to yank that away from the child and traumatize them and make them cry for an hour before they fall asleep after exhaustion? If it's summer and it's 100 degrees out and they're kids that are playing in the street under a sprinkler, are we going to take that away from the child and you're going to order me to force the child to stay in the home and look out the living room window and watch all the kids play and have fun while my child suffers and can't go outside? If there's something that's good for a child and something that's best for a child, why would you take that away? All the science and all the data says you take a parent away, you traumatize a child. You're ordered to traumatize a child. What is the finding of fact of something that I did that's more dangerous than the automatic danger of taking the child away? And I've talked about this in other videos. In other words, if you take me away from the child, you're automatically hurting the child. You have to find something that's worse about me being around the child, like I'm a child molester, I'm a child abuser. The mother's accusing me of that with no evidence. So in the meantime, you can't do anything. You can't give a criminal defendant the death penalty until after a jury finds them guilty. You can't punish and harm the child right now and harm me and my parental rights and constitutional rights without due process and a fair hearing. If you're just going to go off of prima facie allegations, you guys need to know the word prima facie. That means on the surface. If you're just going to go off of prima facie allegations, well, the mother's a child molester and so is her new boyfriend. Give me the kid. If you're just going off of prima facie allegations, if you're just going to go off of words, then give me the kid. My allegations are worse than hers. She's saying I have an anger problem. I'm saying she's a child molester. Give me the kid. See, when a court makes a stupid ruling, you point out how stupid their ruling is and how it's in violation of constitutional case law or the law. You know, I talked to a guy earlier today. The guardian ad litem didn't interview the child. The guardian ad litem said, I don't have to interview the child. And we looked at the law in his state, and the law in his state says the court shall consider the wishes of the child, and the guardian ad litem shall report the wishes of the child to the court, whether the guardian ad litem recommends the child's wishes or not. What it says later is that the court may find out the wishes of the child through the child's own statement, through a guardian ad litem, or another professional. So that lawyer who's a guardian ad litem is lying about the law or misunderstanding the law and only read that part of the law which says what all the court's options are. The court's options to find out what's best for a child or a child's wishes are through the child directly, a guardian ad litem, or another professional. That stupid guardian ad litem said, oh, I don't have to interview the child. No, if you read the rest of the statute, it says they do. So he needs to go to, but he didn't tell the court that. You got to tell the court what the law says. So when you go into court, before you go into court, you got to know what the law says. I was talking to somebody else the other day. She was saying, oh, well, you know, this is defamation and this is that, and they can't do this and that. She's just making up her own rules. And I told her that. You can't go into the court of law and make up your own rules and say, this is my argument. You have to follow their rules and their laws and the laws that govern those courts. So you have to learn this stuff and absorb it and then spit it out to the court. And then you have to make them look as stupid as possible. So if the court says, I'm going to take the father away from the child and traumatize the child because the mother's alleging, and while we're investigating to see if you did it, we're going to traumatize the child as if you did it. You need to talk to the judge like that, but all of you are afraid to talk to a judge like that, so the judge never hears a logical argument, so the judge does their typical, illogical, bigoted presumptions, and they do what they routinely do. You have to go in and disrupt that. See, the problem is not the court system as much as it's all of you guys out there not challenging what the court said. For years we had Jim Crow laws. For years we had separate schools for black kids and white kids. Then came Plessy versus Ferguson in the late 1800s, said that separate cabooses, separate water fountains, separate schools, separate but equal is equal. And then we realized, wait a minute, the kids are going to schools with no books, broken windows, no air conditioning stuff. And so Brown versus Board of Education, when the culture in America was changing and more people's hearts were changing, Brown versus Board of Education, some lawyers got in there and stood up for justice, even though it wasn't popular, even though it wasn't cool, and it was about 1950 something. Even while we had Jim Crow laws and black people's churches were being blown up and Martin Luther King was being sprayed down by hoses or attacked by dogs or jailed just for exercising his free speech right as a free American citizen. The Brown versus Board of Education, some lawyers got in there and unbrainwashed the courts into believing the reality of the freedom for all people. You have to go in and unbrainwash the court of the equality of a father. If you don't do that, you lose. A lot of you don't get that. I tell you what the answers are in my videos over and over and over again. And then you don't say that in court because you don't want to hurt the judge's feelings. And you have to hurt the judge's feelings and tell them that they're wrong. Or you don't want to tell the judge that they're wrong. What the hell do you think a lawyer does? A lawyer goes in there and tells the judge, this is what the law says. Or if a judge gets it wrong, you do a reconsideration. Why do you think Court of Appeals exists? They overturn judges every day in this country, which means the Court of Appeals are saying the judge is wrong. This is how stupid, maybe I should make a point. This is how stupid it is when they say, don't go into court and tell the judge that he's wrong. Courts of Appeals and the Supreme Court and other courts tell judges that they're wrong all the time. If they can do it, why can't you? As long as you're citing the same law, especially if you have case law or clearly written law, like the guardian ad litem example I have, that they're wrong. Tell them what the law says. You don't have to say you're wrong. This is what the law says. You have to fix it according to this, Your Honor. Stand up for yourself.